So today we will be talking about inadmissibility into the European Union. So what is the definition of inadmissibility? Inadmissibility means that due to a certain personal circumstances, you are not eligible to enter or reside temporarily or permanently in one of the states of the European Union. There are many reasons for this factor to happen, but today we will focus on criminal records. How can a criminal conviction in a EU country or a non-EU country impact your admissibility status into the European Union? So first, I would like to focus on nationals of countries that do not require a visa to enter the Schengen area up to 90 days. So these citizens, such as of the United States, United Kingdom, and, for example, Canada, Japan, South Korea, can enter the European Union for a period of 90 days without needing a visa. As of the status quo, even if you have a criminal record and you're a citizen of a so-called visa waiver country, you're still allowed to enter the European Union. That will change as of autumn of 2026. I mean, the ETIAS system has been postponed for couple of years by now, but ETIAS, as I mentioned in one of my previous videos, stands for Electronic Travel Information and Authorization System. It's essentially an electronic travel authorization that will determine if you are eligible to enter the European Union or not. It is modeled after the Canadian ETA or the US ESTA system. So, if you have a criminal record, as of now, you are allowed to enter the European Union. However, after autumn of 2026, this will change. If you have been convicted by a court of law in your home country, you will need to declare it on your ETIAS form. In case you have been convicted of a serious crime, you may be permanently inadmissible to the European Union. However, if you have been convicted of a less serious criminal offense, you will need to apply for a Schengen Type C visitor's visa, where you will need to talk to a consular officer who will determine if your criminal conviction bears any form of inadmissibility. If you're a citizen of a country that requires a visa to the European Union, then you might or might not be asked to provide the certificate of no criminal convictions. If you have been convicted of a crime, it all depends on a couple of factors. First of all, how long ago was the offense, the nature of the offense, and the punishment for the offense. If you were convicted for a small crime, let's say shoplifting, petty fraud, or petty theft, you might be still admissible into the European Union. However, a more serious crime, as pointed out earlier, can result in a permanent disqualifier. A more complex issue is if you're a non-EU citizen and have been convicted by a court in the European Union after April 2012. If you're a citizen of a third country, that means any country outside the European Economic Area and the Swiss Confederation, your criminal record is visible in the so-called ECRIS, or European Criminal Records Information System. Therefore, when you would be applying for an ETIAS, this would be seen and you would be disqualified from applying for electronic travel authorization. The good news is that most European Union countries have so-called rehabilitation of offenders statutes of limitations, meaning that if you are convicted of a certain offense, after a period of time, this offense will be archived and erased. The only exception to this is the Republic of Ireland, which is so far the only country in the European Union where criminal records never expire or are never erased. In the case of a complex question such as a criminal conviction, and if you need to travel to the European Union, if you have any questions of this sort, do not hesitate to contact Crowder Solutions.